and the UPDF for 80% of this bill, especially where it concerns the welfare of members of the Uganda People's Defense Forces. I don't think we could have, or we should have, any contradiction, because all policymakers are very interested in having members of the UPDF catered for their welfare, including those that have become casualties. They are injured. How does the public look after them? And I think the bill goes a long way to address some of those. And I've got to congratulate you, Honourable Minister. However, there is only one aspect listening to my colleague and also following the public conversation. Only one. And we are shifting the attention of a very good bill to one issue: trial of civilians by the army courts. That is all. That's where this contradiction is coming from. Nothing else. We should be speaking the same language. So what is the issue exactly? Mr. Chairman, I would like to speak with my head, but also with my heart. In conversations like this, sometimes we use our hearts, become emotional, and we forget the common sense. Or sometimes we are too brilliant and we don't think correctly. I want to talk directly to the court-martial officers who are here. All this problem has been caused by you. All this conversation has been caused by you. Why am I saying it? You failed to do what you are supposed to do in the law and veered into other things. And where you would have a legitimate case, like I'm going to support you on some aspects, here, you've spoiled your case. So as we give you a law, don't cause us more contradictions and problems. Let me give you an example. If there is this civilian Abdul Katuntu found with grenades, artillery pieces, why would, even if I'm a civilian, why would anybody have objections in me being tried by the court-martial? Because that is the purpose of the court-martial. These are weapons which ordinarily should be a monopoly of the UPDF. These are just war materials. A civilian who is having these sort of weapons, caliber of weapons, really, we would not be so much having a wider conversation. But if you start to pick a helmet and that become, what do you call them, these people? Is it called beret? Whatever they are. And that becomes an issue. You are vulgarizing the issue. That's what the problem is. In law, and the landed Attorney General knows this, we all agree, if you aid and abet a crime, you are as culpable as the principal offender. That's the law. And we will not be having this problem if you people were restricting yourself to real service offenses and civilians aiding and abetting crime. We will not be having this conversation. Please listen to us. But once you veer into other issues because of other reasons, then you miss out on legitimate support. I hope you've listened to me. But I've looked at you, especially the gentlemen who are lawyers the other side. Please listen to what Ugandans are telling you. Just restrict yourself to the law and the purpose of the law. Let us go to the law now. Mr. Chairman, court judges came to the same conclusion. All of them had different reasons. So, you see, somebody will pick one reason from one judgment, then he thinks that is the Supreme Court decision. And thus, maybe at some point, we need now to sit ourselves and reconcile or harmonize the reasonings given by different judges. Because there is no single judgment which gives the same reasons. All judges came to the conclusion that it was unconstitutional, but giving different reasons. So can we go and address the reasons within the different judgment, such that we talk from the same length? Colleagues, you need to read those judgments. They are quite a number. And there is no lead judgment, except that the other one was the senior judge. Because if there was a lead judgment where all judges agree with the lead judgment, that would have been even easy. But the problem is every judge wrote his own judgment, but they concluded the same way. Now, to go back to say this is what court said, that's where I think we are having a problem. And we need to sit. I hope we get time as lawyers, read as lawyers, including the Attorney General's chambers, and we can harmonize. I hope we get some experts to give us some idea. You've invited them. And we can harmonize on that one, because it's quite easy to do that. Second, is it third? In a number. Mr. Chairman, let us look at clause 7. C. Clause 7C. Honourable Minister, why do we have this clause anymore in our laws? 7C. Members of the High Command as of 26 January 1986, whose names are set out in Schedule 3 to the Act. You know, I don't think it's very good drafting and legislating. To legislate for individuals. It is E. Yeah, it is actually E. This is not good legislation. That we are legislating that Abdul Katuntu is a member of the High Command until he dies. Really? I think we need to, first of all, the NRA has since then metamorphosized into the UPDF. It has moved on. Medals have been given. People have retired. I think the army should move on. For example, in this particular clause, Honourable Minister, assuming one is likely to survive up to 100 years, just imagine that you are having a 100-year-old officer to be a member by law of the High Command. It doesn't make legal sense, really, even common sense. So I think at some point, maybe this I should be talking to the UPDF, not to the minister. At some point, you need to revisit this principle. The officers have served, we've recognized them, they have retired, let them live their own lives. They don't have to be members of the army organ, top army organ by law. No. No, I think we need to revisit this. And I hope at some point you concede and we move on. Honourable Minister, look at page 15, U like Uganda. The commanders and experts as may be co-opted by the President to advise the High Command. You see, if you are advising the High Command, then you can't be a member. I think the High Command can co-opt people to advise them, not necessarily as members, but to bring their expertise. For example, we have seen members of cabinet, but there are people who sit in cabinet and advise cabinet, not necessarily them being members of cabinet. You would find, for example, National Planning Authority boss or Secretary General of the ruling party. I don't know whether it's possible. Those who come around, they listen into cabinet and they can be advised, but not necessarily that they become now members of the High Command. You need to look at this critically, because you need the services of advice, of experts. But you can't have an expert and then you are saying he's now a member. He's coming in as an advisor. And that's the power we need to give to the President to seek advice. Mr. Chairman, there is a good innovation by the bill of cross appeal, where you can appeal to the High Court. I think it's close. Clause 57?
Court of Appeal. This is a high court. They have created a high court.
You see, I still have a problem. When you look at 2, clause 2, 225, clause 2. I don't know, Attorney General, whether you're there? Subsection 1 shall not affect the operations of any sentence imposed by a court martial other than a sentence of death imposed by the general court martial. You see, it means that you can only appeal about death and whether the trial was proper, but doesn't affect the sentence. Why should you have such a clause? That if somebody has been sentenced to life imprisonment, for example, and then the Court of Appeal has found that it was an illegal trial, the sentence is not affected. That was my interpretation. I could be wrong. Because it said, subsection 1 shall not affect the operation of any sentence imposed by a court martial other than a sentence of death imposed by the general court martial. So, if you had other reasons, you could explain to see whether this particular clause is not going to be misread or misconstrued to mean that you can actually find impropriety in the sentencing, impropriety in the legality and of the trial, severity, and or even lenience of the sentence, and yet it is not affected by the decision of the Court of Appeal. And why appeal to the Court of Appeal? I thought this is a subordinate court under 129. And subordinate to what? To the course of record. Meaning, if it is subordinate, it should be able to appeal to the High Court because it's subordinate to the High Court. Why are we jumping to the Court of Appeal? Yet this is a subordinate court. The chairman, there are two things I want us to address about parallel or competing jurisdictions. Already there is a penal code provision which provides for some of these offenses unlawful possession of firearms, for example. And now all the firearms, you brought them here. What happens to the provisions of the penal code? Or we are repealing the penal code by necessary implication. Are we doing that? Because those provisions are there. And why are they there? It's because there are other weapons. For those of you who are used to weapons, I just see them. There are other weapons which are like for personal safety. For example, the small one, they call it a pistol. Yeah? It is now also listed, that one. But I see so many people carrying them. In any case, since when did a pistol become a monopoly of the UPDF? The word used in the bill is monopoly. But I see so many people carrying them. I see even the police has weapons, doesn't it? The prisons has weapons, doesn't it? The Wildlife Authority has weapons, doesn't it?
Private security.
These private security people have weapons, don't they? Are those weapons which the police has a monopoly of the UPDF? Does the police need permission from the UPDF to hold those weapons? Does prisons need permission from the UPDF to hold those weapons? Because there are two categories of weapons, in my view. I'm sorry, I'm not an expert, but in my thinking. There are these which are meant for purely war purposes. I think Lieutenant General Herrero here will help me. He's the one who knows those things. This one you use to do very bad things to other people. No, that was your one. You know, those you use to attack enemies. For example, you know, like an artillery piece. There's this one with too many guns, too many bullets, or whatever it is. Yeah, or either Honorable Chama Sweat or the other one who said he was a. Okay, let me conclude. I don't want to excite people. There are those weapons, and Honorable Minister, you would get my support for those category of weapons, which we think are purely for UPDF. And no civilian should, under any circumstances, own, or even whether lawfully or even illegally, own that weapon. That one you'll have my support. But there are weapons which I think cannot be said to be a monopoly. You can't say monopoly, then you go ahead and you bring almost all weapons and you say they are what? They are monopoly. I think there is a problem there with the law, and we need to address that so that we are so clear. These people who are charged with the responsibility of keeping us safe, and they have been given equipment, we want to protect the equipment. That one they use to keep us safe. But the other equipment which you share, including with the civilians, some of these MPs carry them, by the way. Even other people on the street, they're carrying these small pistols, and so on, they do. So those cannot be your monopoly, and don't bring them as a monopoly. Then the other issue, Honorable Chair, I think just look at these classified materials. There are some which shouldn't be here, like this is shoes. Yeah, please. If we had to start looking at shoes, this one looks like an officer's shoe. Really, Honorable Boss, please, stop this. Because people are going to start looking. So, by the way, this shoe is gazetted. Come on, it's for officers. Please, don't vulgarize the law, please. Because we